because now we're going to switch it over and start looking at legal issues with DLI's legal representative, Kate Berger.
Welcome. Nice to see everybody here. My name is Kate Berger. I'm an attorney with the Department of Labor and Industry, as John said. I've been at the department for a very long time. I won't say how long, but I'm going to talk to you. I've been asked to talk to you about three things today. The first thing is just an overview of cases in the last couple of years that might be of interest to you. The second thing is about intervener resources to the extent you folks intervene in litigation. And the third, and the most dear to my heart, is to talk to you a little bit about the rule adoption process and to encourage you all to become active participants in that as we proceed to amend, to update the rehabilitation rules. Now, when I was driving in this morning, I live over, by Southdale, Southwest Minneapolis. I was blinded by the light. I don't know if anybody else was coming east. I was so blinded, so I'm having. I don't know if I've recovered yet, if I can see my notes. So if you see me holding this up in front of you, it's just because I was blinded this morning on the way in. I'm going to start. First of all, I'd like to acknowledge Matt Joby. Matt, you want to stand up? Okay, there's Matt. And he is an attorney with the department, and he prepared the case law summaries that you have in your packet. I think there's about 10 or 12 of them. What I am doing, the summaries are an overview, and I'm going to provide a little bit more detail about those summaries and also what I think is probably significant and relevant to you. There are the summaries prepared by Matt, and what I'm going to be talking about with the summaries are not necessarily every single issue raised by the court, because the cases rarely have just one issue. There's a lot of issues. We focused our summaries and my overview of the cases on things that we thought would be of most interest to you. You'll see that a number of the cases, one of the things I'd like to touch on is that a number of the cases affirm or sometimes reverse the compensation judge based on the standard of substantial evidence. And this means that the decision turns on the compensation judge's findings of fact. And one compensation judge might have found one way, and the identical set of facts another compensation judge in that case might have decided a different way. The Workers' Compensation Court of Appeals looks at whether or not there's substantial evidence to support the compensation judge's decision, the judge's findings of fact. The court has actually said that if there's substantial evidence, it defers to the compensation judge's findings of fact, even if the Court of Appeals would have decided differently. So a lot of the cases I'm talking about today, you'll note that that phrase is used over and over and over again, that this is a substantial evidence case. And so that means that it is of limited precedential value in future cases. The courts cite them, the parties cite them, but really a lot of times what they're really talking about is, do the facts of the case we have before us now, how different are they from the facts in this other case? And so we have to be careful when we're looking at cases that are based on substantial evidence. On the other hand, if there's a legal issue, what does this statute mean? What does this rule mean? Then the court just looks at that independently and doesn't necessarily give the judge any deference. I also want to point out, and I apologize for those of you who already know this, but I understand that there are some newer folks, some interns maybe in the audience. I do want to point out that there is a difference between statute and rules, and so sometimes the courts will be talking about rules, and sometimes the court will be talking about statute. And so if a case cites a statute in workers' comp, it generally starts with 176. So for instance, the rehab rules are in Minnesota statute section 176.102. That is a law enacted by the legislature. There are also work comp rules, and sometimes the court, in the cases that I'm talking about today, will talk about the rules. And the work comp rules have 8 digits, and the work comp rules governing rehab are in Chapter 5220, point 0100 to point 1900. And the decisions talk about both statutes and rules, but it's important to know the difference because, again, the rules are enacted by the statutes are enacted by the legislature, rules are enacted by the Department of Labor and Industry, the work comp rehab rules. A rule has the force and effect of law, but it cannot conflict with a statute. So sometimes you have a situation where the statute, where there's a rule, and then the legislature changes the statute, and then if the rule conflicts with that, then that rule becomes moot, to the extent it conflicts with the statute. So I will mention to you that there's also a website available to you. How many people have signed up for Compact? Labor and Industries Compact. Okay. You'll see at the back of that there's a summary of cases. The Work Comp Court of Appeals head notes of their cases. And if you ever read those and you're interested, well, what was this case really about? I'm intrigued about this. I would like to know more. Decisions by compensation judges are not published, but the decisions of the Workers' Compensation Court of Appeals is published. So I'm just going to show you real quickly. If you are interested in those, you just Google Work Comp Court of Appeals, Minnesota Work Comp Court of Appeals, and it'll bring up this page. Is this working? Yes. And then you can click on decisions, and if you know what year it was issued, you can do it. Otherwise, you can just type in the name in the search box here, and it will bring up the case, and you can read the case in its entirety. And so that is, if you ever are looking at those cases, and you'll see by what I'm talking about with these cases this morning, that sometimes there are facts there that you really don't get from the head notes, because the head notes are just the court's abbreviated overview of the case. So let's get started. I will note also one more thing is that there are a number of levels of disputes in the workers' compensation system. A lot of cases start, particularly medical and rehab cases, start with an administrative conference, like on a rehab issue or a medical issue. And those can either be conducted at the Department of Labor and Industry, and sometimes administrative conferences are conducted at OAH. In general, most rehab conferences start at the Department of Labor and Industry. If somebody doesn't like that result, they can appeal that to the Office of Administrative Hearings, and a compensation judge will hold a formal hearing on that case and decide the issue. If somebody doesn't like what the compensation judge did, they can appeal it to the Work Comp Court of Appeals, and that's where you see these decisions. And if somebody doesn't like the Work Comp Court of Appeals decision, then they can appeal it to the Minnesota Supreme Court. So there are a number of layers of dispute resolution. The ones I'm talking about today are decisions that have been issued by the Workers' Compensation Court of Appeals. So I'm feeling like this microphone is being kind of, is it hard? Is it going in and out? And yeah, so sorry about that. Maybe I'll put that down and maybe I'll just try this. Does this work better? Yes? Not quite so annoying? Okay. Sure. Okay, are we good? Yes? Okay, there. All right, the first case I'll talk about is the Washik case. This is a case involving whether or not the insurer has to pay for a handicap accessible van. Purchased in 2004 at a cost of more than $17,000. I'm not quite sure why the claim wasn't asserted for more than 10 years, but the court didn't go into that. But the employee had requested that reimbursement for the van, and also for a later van purchased by a family member in 2014. But that was that second claim. The employee was not an issue on appeal. So the employer paid, or the insurer paid for conversion of the 2004 van. To allow the employee to operate it, but the employee wanted reimbursement for the cost of the van itself. A compensation judge denied it, and found that the van did not enable the employee to seek or engage in employment on a sustained basis, and the employee had no rehab plan to return to work, and the judge inferred from the records that the relevant period that the employee was using the van, that the employee was not capable of working. So the employee appealed this, and the Workers' Compensation Court of Appeals affirmed the denial. All the parties, again, this is an example of substantial evidence. There was a Wong case in 1993 in which the cost of a van was awarded as a rehab expense for a quadriplegic. And the court said, well, the facts of that case are different. In that case, this is a highly educated employee. He was going to return to work. The van was going to help restore him to the job, to his former employment. But in this case, the judge and the Court of Appeals agreed that the employee did not prove that the van assisted her return to work consistent with education, employment skills, physical disabilities. In the 10 years she owned the van, her only attempt at employment was an unsuccessful 5-month part-time job, and that it was not part of a rehab plan for the employee's return to work. So the court again said, they reiterated that there are times when a van is entirely appropriate as a rehab expense, but based on the facts of this case, this is not one of those situations. Second case is the Halverson case. And this case involved an employee who was injured in 2007. She had, at her job, she had health insurance, vacation, an optional 401k. She was earning her average weekly wage was $390. She had a laminectomy in 2014 and began working at McDonald's shortly thereafter. She had had some other jobs at fast food restaurants. She started working at McDonald's at about 20 hours a week. She liked this work. The doctor said that it was likely that this was going to be permanent, that she could only ever work 20 hours a week, but the employee was motivated and really wanted to work more, and her ultimate goal was to become a manager at McDonald's, which would require her to work full-time. In 2015, the insurer filed a rehab request to terminate the employee's rehab services, saying she's no longer a QE, qualified employee, because she had suitable gainful employment at McDonald's. The employer also cited at the hearing that there was good cause to terminate rehab under Rule 5220-0510 because the employee was unlikely to benefit from additional rehab. What's key in this case is that the employer withdrew that defense at the beginning of the hearing, and so their only defenses were that that rehab should be terminated because she was working at suitable gainful employment and therefore was no longer a qualified employee. And the QRC testified that McDonald's was not suitable gainful employment because it didn't provide an economic status that was similar to the job she had at the date of injury. Well, the comp judge said, all right, McDonald's really is suitable gainful employment for this employee, therefore she's not a qualified employee, and therefore her benefits, her rehab should be terminated. And the Work Comp Court of Appeals said, no, you applied the wrong standard here in terminating rehab. The issue of whether an employee is a qualified employee for rehab services goes to when a plan is implemented, not when a plan is discontinued. It has no bearing on when rehab services should be terminated. And in fact, that applies to whether the employee has suitable gainful employment. So even though this employee has suitable gainful employment and may not be a QE anymore, the court didn't really reach that decision, is irrelevant. The relevant law is 176, remember that's the statute, 176.102 sub 8, and Minnesota Rule 5220.0510 subpart 5, involving when a plan can be terminated or modified, and it lists a number of factors. Factors including physical impairment doesn't allow the employee to pursue the rehab plan, the employee is not cooperating, the plan is inadequate to achieve objectives, and again, or the employee is not likely to benefit from further rehab, but the insurer withdrew that as an issue, so the court didn't consider that in this case. So what the court said is that the judge said discontinued rehab, saying that the employee was no longer a qualified employee because she had suitable gainful employment, and the Court of Appeals said that's irrelevant to termination. You got to look at the statute and the rule that talks about when a plan can be modified or terminated, and that was not discussed, and therefore they said that the plan should not be terminated. I will note that this case has been appealed to the Supreme Court, so stay tuned, and we'll see whether or not the Supreme Court agrees with the Court of Appeals on that analysis. The Gilbertson case. This is a case where the employee was a funeral director, and while she was working, she suffered a large herniated disc in her low back. In this case, the date of injury employer offered her a job, but the rehab plan said that she was supposed to return, that the goal was to return to work with a different employer. So again, while this, and so what the Work-Comp Court of Appeals said is that the statute says that temp total shall cease if the employee refuses an offer of work that is consistent with a plan of rehab, or if no plan has been filed with the commissioner, if the employee refuses an offer of gainful employment that the employee can do in their physical condition. And the Work Comp said, well, this was an offer from the date of injury employer. That's not what the plan said. The plan said return to work with a different employer. So therefore, the compensation judge erroneously analyzed the issue and discontinued temp total for an improper reason. Is this done? Oops. Our IT people, you want to? All right, I'll stand over here while he fixes this. So anyway, so that's another case of the Work Comp Court of Appeals looking at the statutes and applying them very specifically and saying that you got to take a look at the plan. And if, in this case, the employee, thank you, the employee didn't, the plan was to return to work different employer, there was a job offer from the date of injury employer, and therefore they weren't going to discontinue the employee's temp total on that basis. A second issue involved in this case was, had to do with the first QRC. There's a first QRC, and during all this litigation, filed an R8 and closed the plan. One of the issues was that whether the employee could switch QRCs. So the first QRC filed an R8, closed the plan, and then a new QRC started providing services to the employee. And the insurer argued that the new provider should have obtained prior approval before providing services. And the Court of Appeals said, no, there was an R8. The plan was closed. When the plan is closed, there's no obligation for a new QRC to require prior approval before providing services. And the Court of Appeals noted that where a QRC chooses to provide services before obtaining approval or approval by the insurer or a judge, the QRC runs the risk of not being paid. But failing to obtain prior approval is not a bar to payment where an R8 closing rehab has been filed, in this case by the first QRC, so no prior approval was necessary. The judge also found the employee to be a QE, and the services of the second rehab provider were reasonable and necessary. And finally, the insurer, or the Work Comp Court of Appeals, noted that refusal of a job offer is not a basis to deny rehab services. Again, this is another case, a lot of issues here. This is another case on appeal to the Supreme Court, so stay tuned and see what the Supreme Court says about those. Yes, we are kind of tight of time, so, okay.
On that reopen, was there a consultation and then the R2 plan?
Yeah, I don't recall
it.
that the case said that, but we do have a copy of it if you want to look at it. You can take a look. I don't recall whether there was a consultation or not. The Hutterly case is next. This is an employee who sustained a back injury while she was working as a nursing assistant for the employer. After being treated by many medical professionals, in 2014 she filed a claim petition for a number of benefits, including rehab services. This employee had a rehab consultation with the QRC in 2014. The QRC said the employee was a qualified employee for rehab since she had work restrictions and was working at a different position. She was working as a clerical position instead of a nursing assistant for the same employer. Because she had to work more hours a week, even though she had no wage loss based on her weekly wage. And the comp judge found that the employee was not a qualified employee because she returned to pseudo-gainful employment with the employer and did not have a wage loss. The employee appealed this, and the Work Comp Court of Appeals affirmed the compensation judge's decision, saying that an eligibility for rehab services is determined by comparing the employee's economic status pre- and post-injury and applying the factors in the statute and rules. Evaluation of the economic status includes comparison of wages, fringe benefits, health, life, disability insurance, opportunity for future income, and other factors such as age, education, interests, and skills, and employment history. So the court said, we understand that this employee might have preferred to work with patients as she was in her nursing assistant job, but that job wasn't available to her because of her restrictions. And the fact that the employee had to do a different job did not mean she was a qualified employee, because there's no evidence that there was any difference between the positions in terms of opportunity for future income, advancement, or fringe benefits. Now again, this is substantial evidence. There might be another case with very similar facts that a judge might decide differently on that. But in this particular case, they said a nursing assistant returning to a clerical position with the same employer is not a qualified employee. The Contreras case is next. I will note that here you'll see an example of what the Work Comp Court of Appeals head notes are. So in your materials, this is what the Court of Appeals, how they describe the cases. They'll give a caption, and you'll note in both of these it says, again, substantial evidence supports in this particular case. The reason I'm raising this case here is that this is one where there's a statute that says if temp total disability ceases because the employee refuses a job consistent with a plan of rehab, there's that language again, or if there's no rehab plan the employee can do in the employee's physical condition, it can't be recommenced in the future. This is a very harsh consequence. So if an employee refuses a job that they can do or that's consistent with a rehab plan, what that law says is, you are forever barred from future temp total. In this particular case, the employee, at the time the employee refused the job, was not actually receiving temp total disability benefits. I don't know why, but the employee wasn't receiving them, received benefits at the time. He received a job offer and rejected the job offer. And so the court said that this does not bar the employee's future entitlement to temp total because he wasn't receiving temp total at the time he refused the job offer. So that's just kind of a technical interpretation of the statute, as opposed to a substantial evidence case. It's a legal analysis. Next case, Rivera. This is a case involving non-cooperation with rehab. The employee sustained both an umbilical hernia for which he lost no time from work and a left shoulder injury in 2011 and 2012. He was terminated in 2013, on May 22nd in 2013. There was a rehab consultation. A week later, the parties agreed to rehab services, and he met with a job placement specialist and signed a JPPA on June 18th. So what the court said here is he was just establishing the plan. So the court denied rehab services for not cooperation, and the court said this was just having a consultation and establishing the rehab plan. There was no non-cooperation during this 3-week period, so he continues to get benefits during this 3-week period. They found that after that, they found that the employee really did not make a good faith effort to participate in the plan, did not conduct a diligent job search once that plan was established, and they said the employee didn't submit job logs, didn't follow job leads, and limited his search to his hometown, and also withdrew from the labor market because he turned down a job offer while attending truck driving school. So in that case, the court said, well, you're establishing a plan that's really not, for this particular employee anyway, that was not non-cooperation for that 3-week period. So they reversed the compensation judge on that basis. The other thing I added, I don't think it's in your case summary, but I found this kind of interesting and useful to know, a good reminder. This is not the first case where the court has said this, but this employee had uncontrolled diabetes. It was not related to his injuries, and he claimed treatment for this diabetes. And the compensation judge said, no, your work injury didn't cause your diabetes, so I'm not going to award that treatment. And the Supreme Court said that the relevant issue is not whether the diabetes is causally related to the work injury, but whether the medical treatment for the diabetes was reasonably required to cure and relieve the employee from the effects of the injury. And in this case, there was some talk of surgery for the umbilical hernia, and while his diabetes was uncontrolled, the surgeon was unwilling to do that. And so in order to have that surgery, he needed to get his diabetes under control, so the court said that that treatment was compensable. So I just thought that was a good reminder. There have been other cases similar to that in the past, particularly relating to weight loss necessary before surgery. The Medlock case, I'm not going to spend a whole lot of time on this because it is very confusing. Even to me, I had to read it a number of times. But there are really two issues here. This employee was injured while working on a production line. The judge found that he was temporarily totally disabled through September 24th, 2013, but no longer disabled after that date. But after that, temporarily totally disabled after that date. But after the employee reached MMI, they also found the employee had not reached MMI and was a qualified employee for purposes of rehab after September 24th. So the employer insurer said, this doesn't make any sense. You can't say that the employee didn't have work restrictions and wasn't disabled after September 24th and then turn around and say, but after September 24th, the employee is entitled to rehab because of his restrictions. And so so this is an example of how when you have to read the cases very carefully to see exactly what the court is saying and what the facts of the case are. And in this case, what it really was is that the compensation judge and the medical providers were uncertain about ongoing restrictions. A nurse practitioner is the provider that the judge relied on and said that the employee could probably work without restrictions after September 24th and that it would be painful but not damaging. The comp judge concluded that the employee was restricted through at least September 24th. The comp judge did not find that the employee had no restrictions, just that the employee had not established based on that medical report that said he could probably go back to work. But the employee's testimony was that he was still having all kinds of problems. The judge acknowledged the medical records were unclear about whether the employee was restricted. And so they said that basically I think what this really is that the employee just hadn't established his entitlement to total disability because of that nurse practitioner's statement. But the employee testified he still had ongoing problems. The medical report was equivocal, and so they said that in this case, the comp judge may rely on the employee's testimony alone about his physical capabilities, both where there has been an unrestricted authorization to return to work or where no medical provider or physician has issued restrictions on the employee's ability to work. And in this case, they said the employee was entirely credible, so we're going to give the employee rehab assistance, even though he had not at this point established entitlement to temp total. So the case doesn't stand for the legal holding that an employee who has no restrictions is entitled to rehab. To me, it just, it does say, longstanding case law, that in these cases, these hearings before compensation judges, an employee's testimony about the employee's abilities and restrictions is relevant, and the judge can consider that and can accept that testimony if it's credible. I don't know how to pronounce this next one, Samgadi. This is a case where the employee slipped and fell on a pool deck. She was diagnosed with a cervical strain and concussion. She saw many providers, many specialists, many diagnostic tests for a multitude of symptoms. And the judge, compensation judge, after hearing, found that her work injury resulted in ongoing symptoms of headaches and cervical disequilibrium, resulting in dizziness, imbalance, and nausea through the date of hearing. She was also claiming visual problems, but the judge denied payment for the treatment of visual problems. Workcomp Court of Appeals found substantial report. Then the employee received medical management beginning in November 2012, and the employer-insurer in 2013 filed a rehab request seeking to terminate rehab services because the insurer claimed the injury had completely resolved and she no longer had work restrictions. At the hearing, the comp judge found that the QRC services were not reasonable and necessary, and the Workcomp Court of Appeals affirmed, this again a substantial evidence case, that the employee had been released to work during the entirety of the disputed period that rehab services were being provided. The services were not designed to help the employee return to suitable gainful employment, but rather the services were focused on litigation and medical management. The court found that much of the bill time was associated with preparing for the hearing, and so under those circumstances, payment for those services were denied. In Hoffman, this is the 2008 case where the employee hurt her knee and she filed a claim petition. The judge found that she had aggravated a pre-existing degenerative condition, so that was a compensable work injury, but that the employee had no permanent partial disability or restrictions and denied the employee's claim for a rehab consultation. On appeal, the work comp affirmed, saying that a determination that the employee has completely recovered from an injury and or has no employment restrictions may defeat a claim for a rehab consultation. So this is again not new, but what the court is saying, is that when there is when the employee is completely recovered, that's one of the few circumstances when the employee might not be entitled to a consultation. And then I'm going to talk a little bit about intervention cases. I'll have to start using that, otherwise it keeps closing down. There's 3 intervention cases, and then I'm going to kind of segue into what resources are available to you. The Schwammel case, first of all, this is a case that, first of all, involved the question is whether or not there was evidence to support the compensation judge's findings that the employee was a qualified employee, that a job search would have been futile, and that the employee cooperated with rehab, and the QRC reasonably focused on providing medical management. And the Court of Appeals noted that the fact that that the goal of a rehab plan is to return the employee to the date of injury employer does not automatically mean the employee is ineligible for rehab services. And the court also engaged, if you're interested in this, you might be, because I know a lot of QRCs perform medical management, so go ahead on the Workcomp Court of Appeals website and look up the case if you're interested. But the Court of Appeals engaged in quite a discussion of medical management by the QRC, which the court noted includes services that assist communication of information about the parties, about the employee's medical condition and treatment necessarily to facilitate return to work. And in this case, the court noted that the QRC maintained careful and meticulous records. I think the comp judge found that. Provided those records to the employer-insurer along with updated R3 plans, and that medical management was focused on enabling a return to work, and therefore it was compensable. They also, this is the intervention issue, the employer-insurer also asserted that the claim should have been denied because the QRC did not appear in the case to substantiate his request for reimbursement of rehab services, rehab expenses. And the Court of Appeals said that attendance by an interviewer may be waived, so take that with a grain of salt because there's new legislation here, and that the employee has a right to make a claim. This is the key piece here. The employee has a right to make a claim directly for rehab benefits, even if the QRC has not intervened. So a lot of times it's the employee pursuing the claim, and sometimes you might decide to intervene, and sometimes and become a party, and sometimes you might just let the employee continue with assert the claim. And then in a couple of months later, the Supreme Court issued the Sumner decision. Maybe a number of you have heard of that, and that decision said that if an intervener intervenes, if there's an intervener, that intervener has to show up, has to attend the hearing. Now, the OAH issued a very detailed and lengthy standing order on on implementing the Supreme Court Sumner case about how the QRC or any intervener has to show up. Again, this case has somewhat been superseded by legislation because in response to the Sumner case, the legislature enacted a law that I'll talk about in a minute. And then the Irvin case is not in your materials, but I will just mention it here. This is a case where even though the employee had asserted the claim for the claim for the medical treatment by a healthcare provider, the healthcare provider intervened, but intervened late beyond the statutory time frames. And so the court said in that case that a provider is not required to intervene. The employee can assert the claim, but once the provider decides to intervene, that has to follow the requirements of the law. So even though the employee said nobody else would pay for this treatment, the health insurer wouldn't, the work comp insurer wouldn't, this provider did provide this with no guarantee of payment, intervened a month or two late, and the court said, well, we have to follow the law. We really think that that was a great thing the provider did, but the law says that they don't get reimbursed because they provided late or intervened late. So now what I would like to talk to you about is what has happened since then. And in your materials, there are materials in here about intervention. And I'm not going to go through all of them. There's an overview of the Work Comp Advisory Council bill that was enacted in 2016. There's a link there. You can get it on the Revisers webpage if you're interested in it. I'm just going to start with on the second page, section 6 to 12. This amends the intervention statute. You can read each of those sections. I want to make sure that we get through all of this, but the most important thing to note here is that the big change in this law is that interveners no longer have to attend. So you can intervene and not attend the hearing. However, a party can decide that an intervener needs to be there and can file a motion, or the judge on his or her own motion can decide that an intervener needs to attend the hearing and might issue an order. So if there's if you have intervened in a case for payment of your rehab services and you receive it, you don't have to attend under this new law. However, as of August 1st, however, if you get an order from the judge, then you have to. And if you don't attend when you've been ordered to do so, then the benefit, then your right to receive reimbursement is extinguished. So there are all kinds of time frames about when a motion has to be filed that I won't go into. There's an exception that if the judge finds good cause for failure to attend, if you're on your way to the hearing and you get in a car accident, probably the judge is going to excuse that. But otherwise, if you get an order to attend, you have to do it. Of course, that doesn't mean that you can't. If somebody, a person, a healthcare provider or a rehab provider that intervenes is, of course, free to attend the hearing and participate in as much as they want, but they don't have to. You can also request permission to appear by telephone if you want, if you'd like to do it that way. But the most important thing is if you want to intervene, even if the employee has asserted a claim, pay attention to whether you have been ordered to do so. And the other thing you have to remember is that you still have to submit evidence. The law requires that you submit evidence. So I know that our VRU, is anybody here from VRU? I know that our VRU folks, when they intervene in cases, they submit a packet of exhibits and a cover letter to OAH, you know, a few days before the hearing, and they send it to the employee and the insurer, and say, here are my exhibits for the hearing. I won't be there, but here's the support for my intervention claim. So I've also attached, the Office of Administrative Hearings has a document where this was published in, they have something called Workers' Compensation Bar Update. This was published in July 2016, right before the new law went into effect. And this is OAH's summary of what an intervener needs to know. Again, if they're ordered to appear, they say the claim for reimbursement will be denied if they don't appear. And at the bottom of the page, it does talk about an intervener is required to present evidence in support of the intervention claim at or before the hearing. So you can submit your packet of exhibits or whatever before the hearing. The other thing I will point out here is that the response to objection, the new law actually says that objections to an intervener, those objections have to be specific and detailed. So take a look at those, because I know in the past sometimes you'll see objections, they say kind of like, well, we just reserve our right to object and put the intervener to proof of their claim, or they say something very vague like that. I think that won't fly anymore. So if you can't figure out why they're objecting to your services, sometimes it's obvious, it's just an underlying liability issue or something, but if they're saying, well, we don't think those rehab services are reasonable and necessary, and they don't say anything more, well, that's not specific. That's not specific and detailed. So I think you should feel free to comment on that. That if you're submitting a response before the hearing, that this, or even at a pretrial or something, that I can't figure out why they're objecting to my services. So that's something new in the law. The next page is also an order that comes out when somebody has intervened. Last I heard, I checked with folks in my office who do litigation, and they said they think these are still coming out, but this is an order that OAH issues talking about intervention. And so if you intervene in a case, you might see one of these orders, and again, it's OAH telling you, here's what you need to do, pay attention to this. So in summary, I'll just summarize the highlights here. You're not required to intervene if the employee has filed a claim for your rehab services. Remember, though, that the employee's attorney is not representing you. The employee's attorney is representing the employee. Sometimes your interests are exactly the same and you're entirely comfortable with that, particularly if it's like a liability issue or something that you don't really have any control over anyway. But if it's something like the reasonableness and necessity of your services or something, you might have more of an interest, and that might be more important for you. But anytime your services are at issue, you are entitled to reimbursement. If you file a motion, my second point, if you file a motion to intervene, there's a form on the OAH website, which I'll show you in a minute. Use the form. Attend the hearing. Oh, file it timely. That one case said, even though the employee's claiming it, if the QRC didn't file it timely, they're just out of luck. So pay attention to the time frames. If it's an administrative conference, you have 30 days after receiving notice of your right to intervene to get that motion in. If it's a hearing at OAH, you have 60 days to get that motion in. So pay attention to the timelines because of that recent case. Attend the hearing if you're ordered to do so. If you don't, but you can attend even if you're not ordered. If you don't attend the hearing, or if you attend by telephone, the judge gives you permission for that, submit your evidence to OAH before the hearing. Make sure you get something in there to support your exhibits, to support your claim for reimbursement. Respond to an objection. If there's an objection that either you know what it is and you disagree with it, you can put that in your evidence, or if you can't figure it out, you can say that as well. That this is not detailed and specific. Yeah. Uh-huh.
If the employee's filing the claim for rehab,
Yeah.
and we don't have to intervene, right? But then there's a stipulated settlement. Where does that leave the QRC?
Well, if you haven't intervened, my understanding is...
Now, the question
Have you
was,
intervened?
no, you said earlier that if the employee is requesting rehabilitation services and the QRC then has not intervened, okay, and they come to a stipulated settlement, which is the new name of the game, has been going on quite frequently for the last couple of years, where does that leave the QRC with the rehabilitation services?
Well, that would be a reason to intervene, to make sure that you're at the table, because you don't have a right to be at the table. My understanding, somebody correct me if I'm wrong, but my understanding is that the attorneys will still normally contact the QRC and talk to them, but
then
the
again,
QRC is not entitled to be at the table and is not...
Yeah, I must be missing something then, because if I don't intervene, okay, and there's a claim petition filed and the insurer is trying to deny rehabilitation services is one of them. You said that earlier that if I choose not to intervene, and I'm riding on the employee's request for rehab services, okay, and I choose not to intervene, okay, then there's a settlement conference that comes up before any hearing, okay, and now the parties reach a stipulated settlement. You can't have one and not have the other. In other words, if you're telling me that I don't have to file the intervener because there's a claim petition filed and it includes rehabilitation services, so the employee's asking for the rehabilitation services, okay? And now there's a settlement conference that's scheduled, and the parties reach a stipulated settlement, okay? So what you're saying is if I'm not part of the stipulated settlement, as the parties sit and negotiate this thing, okay, and I haven't filed the intervener because you said I don't have to file the intervener if the employee's filing a request for
Then you're at the
rehabilitation.
mercy of the employee settlement.
So what you're really telling us is we should always file an intervener.
If you want to avoid that situation, yes. You need to pay attention about what the issue is. Now, if it's a liability issue, the issue is that you might not get paid anyway, because if the judge finds that there's no liability, then, and you've been providing services all along, then as the court said in that other case, you're taking the risk of not getting paid. But that's why in fact the OAH website, they have that question. The question is, well, should I intervene or not? And their simple answer is, if you want to be a party, if you want to be at the table, if you want some control over these things, then you should intervene. So I didn't mean to suggest that it's not a good idea to intervene. I'm just saying that the cases say you're not required to intervene. The employee can pursue your claim, and then you're subject to whatever happens with the employee's claim. So here's the Office of Administrative Hearings website. I just want to show you what they have here. You can go to their website. If you go to Lawyers and Litigants, Work Comp Resources, and then scroll down, there's Intervener Resources. So that's the page I have open here. And this case gives you background. It has a link to the motion to intervene. There's a stipulation if you want to do that. If you want to offer the parties a stipulation to settle your claim beforehand, there's provision. I don't know how often that happens, but you can see that here's the link right here. Here's the motion to intervene. That has recently been revised because of the new legislation. And then there are FAQs. So there's all kinds of questions that you might have, and take a look at these. Who can intervene? This gets to the question of all kinds of questions. Where do I file it? How do I file it? What needs to be in there? What do I do with a stipulation for intervention? So this is, helpful information for you. And I encourage you, I won't go through all of these, but I would encourage you to take a look at them yourself on the OAH website. Now, the next thing I wanted to talk about, because we're almost running out of time, and this is what am I doing? How much time do I have here? 10 minutes, okay. So the next thing I'd like to talk about is the department's rulemaking. So the Minnesota Department of Labor and Industry, I don't know if folks have heard this, the Minnesota Department of Labor and Industry is starting to work on amending the rehab rules. They were last amended in 2005 rather, sorry. And so it's about time for them to be updated. And I'd like to show you some resources and encourage you to participate. There is a request for comments, a draft request for comments. It's not finalized yet. For one thing, we're waiting for the reviser to give us a number. But this request for comments is sort of the first step in rulemaking. And rules can only be adopted, again, if the legislature authorizes them to be adopted. And it only, so there's got to be a statute saying this agency can adopt these rules or, on this particular subject. It notifies, the request for comments is published in the state register, and it notifies the public that an agency is planning amendments to rules and invites interested folks to get in on the ground floor of developing these rules. It's also on the Department of Labor and Industry's rule docket page, which I will show you in a minute. So, for instance, a request for comment for those of you, we passed out a draft here, and that will also be posted on the web page for those appearing or attending by WebEx. But this request for comments just notifies folks that the department is considering possible amendments to rules governing voc rehab in Minnesota Rules Chapter 5220. The first category is the subject of the rules. It says we're considering amendment to all of the rehab rules in Chapter 5220, and also considering amendments to the rules of practice governing penalties for failure to timely provide or pay for rehab services. So at the department, we're going through each rule to see whether any part of that rule, including the subparts, should be updated, amended, clarified. So since it's been 10 years, it's time to do that. It identifies the request for comments, identifies persons affected. The request for comments also has to include a list of the statutory authority to adopt the rules. So this is just a big long list of everywhere in the statute, Chapter 176, that the legislature has said the department can adopt rules related to vocational rehab. And so that is a list of the authority that we would be relying on to adopt these rules. Again, an agency can only do it if the legislature has authorized it, and the Office of Administrative Hearings, when they're reviewing rules, the judge, the administrative law judge, will, first and foremost, they will look to make sure that the agency has authority to adopt the rule that they're doing. This is the next section invites public comments. This is the most important section for you. It requires, it tells the public that this is where it says we want you to tell us what you think about the rules, what you would like to see amended, what you think is unclear, what new rules would you like to see, what problems have arisen in the last 10 years that you think that the rules are problematic. And so we want to hear from you. I've been working on work comp rules for many, many years. And this experience has taught me that the more people will look at the rules, the better off we are. There have been times when we first started out where we thought, this rule is perfect. This rule is so clear, it completely addresses this particular issue. We are so proud of this rule, we did such a great job. It goes all through the process, and at the end you get a call. Did you mean this or this? And then you're just like, oh gosh, So my experience is that really is prevented by folks looking at it, folks getting in touch with us and saying, we don't understand what this means. We don't agree with this. If you do this, it's going to cause this problem. And have you thought about that? And a lot of times we haven't, because I am not anyway, a practicing QRC. And so I can't encourage you enough to get involved in this process on the ground floor. Let us know what you think about the rules. Let us know what you would like to be changed. You have to live with the rules when they are finally adopted, so you will want to participate. It is also an excellent time to get started, because the farther along you are in the process, it does get a little trickier to change them. Once you publish them as rules in the state register, you can't add new rules. You have to stick with what you've got, and you can clarify them, but then you have to go through a whole new process if you're going to substantially change them. So this is just a great time to do that. There's also a second notice that's published after the rules are finally developed. And then that notice, it gives somebody, it's a formal notice, and it gives you an official 30-day comment period, or 30-day, during which a person can request a hearing. So people sometimes confuse these. This is much more informal. There's no deadline to comment. And in fact, the department is going to post drafts of the rules on our docket page, which I will show you that now. So if you go to, this is an important resource for you. So if you go to the Department of Labor and Industries homepage, everybody I assume knows how to get there. So you go, this is how I get there. You go to About DLI, and then you scroll down to the bottom, and there's that menu on the left. And you click on, well, first of all, I will show you one thing before that. You can click on boards and councils, and we will, we do consult with the Rehab Review Panel, and they're right there. And if you're ever interested in what the Rehab Review Panel is going to be talking about, if they're going to be talking about any of the rules, then you can go ahead and scroll down, and you can see what their agenda is. There's not an agenda yet for the October 14th meeting, but you can see the agenda and the minutes. You can see what happened at the minutes. So that is a resource for you as well, to the extent that they're talking about rules or anything that you're interested in. But if you click on, if you go back to this page and you, About DLI, and you click on rulemaking, you will come up, you'll come to the department's rulemaking page. And you can see there's something here for workers' compensation, and you can see it lists the rules. So for instance, the department, there's here's the opioid rules that we adopted in 2015, so those are rules, and then these are fee schedule rules. The department is working on rules governing the cost of copies of medical records. So this is our docket page. And there will be one shortly, once this is published, there will be a docket page for the rehab rules. So when you look at this docket page, it gives you all kinds of information. Who's the contact person? In this case, it's Ethan Landy, who's another attorney in our department. You can see the request for comments there. There's a link to that where it's published in the state register. Availability of rule drafts. If there are rule drafts, here's where you go to see them. So you go to this page and you click on the rule draft and you look at it and you say, this is perfect. I can't believe that there's no more perfect draft than this, or more likely you will look at it and say, what are they thinking? I got a comment. So then you go up and you can email us, you can give us a call, there's a number there, there's the email address, and you can give us your thoughts. Whatever you say at this stage generally is not part of the rulemaking record. The rulemaking record, really the comments that are received are after we publish the rules in the official rulemaking record. And you'll see that at the bottom of this request for comments. The comments received in response to this notice will not necessarily be included in the formal rulemaking record. We are required to submit to OAH only comments received in response to the rule. But you don't have to submit something in writing. You can just give us a call as well. If there's going to be a hearing, that'll be on here, the timetable, the date the rule is adopted. So this is really your page to figure out what's going on with the rules. And if there's a rule draft there, you can assume that we're still working on it until another draft is published. So be sure to pay attention to this and participate. The other thing I'm going to show you just briefly, and then I will be done, this is going to be really quick, is just the rulemaking timeline, just to give you an overview of what is involved in rulemaking. So in this case, you'll see that it takes a couple of years because Minnesota has, I have heard it said that Minnesota has the most complicated Administrative Procedures Act in the nation, and the legislature keeps adding more and more requirements, mostly having to do with notice to affected parties or local government. So you'll see that, it takes up to a couple of years to do rules, particularly these because they're going to be pretty extensive. Public participation is big. There's also the revisor's office. The governor's office is involved. They want to know what the agencies are doing in terms of, because remember, rules are law. They're the force and effect of law. So there are many, many people here that we need to, that have a hand in. And then, of course, the Office of Administrative Hearings reviews the rules as well. So this is another example. I should give credit to Pat Wingett at the Minnesota Department of Health. She drafted these. There's a 300-page rule adoption manual on the Department of Health's webpage, and this is part of that. And you can see that these are very abbreviated steps. The first two were at the request for comments. Now that's usually done at the same time of just letting the governor's office know that we're about to do this. The agency has to draft a SONAR, statement of need and reasonableness, where the agency has to do a cost-benefit analysis and justify every single rule amendment that's made. There's more governor's office review. Then there's the formal notice of it to adopt rules. If there's 25 or more requests for hearing, then the agency has to hold a hearing on it. The Office of Administrative Hearings reviews it, again, for the authority. Is the rule needed and reasonable? What's the problem? Does it solve that the agency has identified, and does this rule do that? Did the agency comply with all the many, many requirements? Assuming OAH approves the rule, sometimes they recommend changes or require changes in the rules. There's another review by the governor's office, filed with Secretary of State, and then the governor has another veto period. So that's sort of an overview of, that's a really broad overview of what happens in the 2 years. And the most important thing I'd like you to remember is that we really do want to hear your comment. Take a look at that docket page, look at the drafts of the rules, and let us know what you think. Okay, that's all. Oh. Can you give me some examples of what a would take as an exhibit or evidence
to present at a hearing to establish why they should get paid for their services?
Well, of course, it depends on what the issue is, but there is those FAQs on the department, on the OAH's website, does say what they're looking for. So your charges, your case notes maybe, I think are some of them. The plan, it depends on really entirely what the issue is. But go ahead and take a look at the OAH FAQs, and they do talk about that.
Thank you.
I will be around, so if anybody has questions, just let me know.
So that was some fairly big news for all of you guys. Since the department is, that's fresh news that we'll be looking at all the rules and that they're under review. So breaking news.